I said earlier that I'm sure one or two of my comments would make people, including elected officials in Milwaukee County, specifically the city of Milwaukee, uncomfortable. That's not necessarily by design, but I don't mind that being the case. Because it is long past time to have uncomfortable conversations in the city of Milwaukee and in southeastern Wisconsin. It strikes me that in the last 5 to 10 years, almost no elected official will buck the trend of everything's fine, everything's great, everything's wonderful. Don't look at the train wreck on the side of the road. Don't look at the situation in MPS. Don't look at problems with reckless driving, with homicide, with DV homicides. Just focus on the positive. The city of Milwaukee, where I live, for the record, is a great city. We have everything from Summerfest to the Fiserv Forum, the Bucks, Marquette, wonderful weather today notwithstanding. There's a lot of good things going on in Milwaukee. But Milwaukee has its, I was going to say fair share, more than its fair share of problems. And the general reaction from elected officials in this community is to just ignore them and to obfuscate and to push them aside and to say, well, it's not my problem, it's somebody else's problem. MPS says it's not my problem, it's the city's problem. The city says, no, it's not, it's MPS's problem. So were I to allow this to go on, I'm confident that we'd be back in 2 weeks or a month or 3 months with no resolution whatsoever. Because I don't believe, at least yet, I'm not fully convinced that either of the defendants actually wants a resolution. The city agreed as part of this grand bargain under Act 12 to the implementation of this law and putting the school resource officers back in MPS. Obviously, I wasn't there, of course, so it's a bit of speculation and conjecture on my part. But obviously, there were conversations that went on at some level between the mayor or the common council, representatives of MPS, lobbyists, school board members, and others, that this trade-off was acceptable. And the city got what they wanted. The city got the 2% sales tax increase. And I know council argued that that sales tax is based on maybe particularities of the law not to be used for general purpose funds. It's to be used for pensions. I'll take your word for that, council. I think it's a side issue. But everybody here knows that money is fungible. If you tell me I have to pay you 10 grand for something, it can come out, if I had it, from my checking account, my savings account, my wife's account. Money is fungible. Okay, so that argument from the defendants that we don't have the money is a non-starter. The petitioners can correct me if I'm wrong. Both the city and MPS have annual budgets that exceed $1 billion, correct?
That's my understanding, correct.
Let me say that again. The city and MPS, not collectively, but separately, each have budgets that exceed $1 billion with a B, $1 billion annually. We're here arguing over $1.5 million or $2 million. That's not even a rounding error on a penny relative to those two budgets. And yet, the plaintiff and other taxpayers and students and parents of MPS kids have sat by for 1.5 years since the law was passed in mid-2023 and 13, almost 14 months since the implementation date, with both the city and MPS, but primarily MPS, flaunting the authority of the court and directly violating the law. That's unacceptable, and it's not going to be tolerated by this court. Knowing both attorneys, I know Ms. Kohlberg better than Mr. Mookie. Is that how you pronounce it, counsel?
Yes, sir.
I'm confident both of them went back to their clients and said, this judge is going to hold you accountable. This judge is going to make you comply with the law. There are judges that won't, but this judge will. So again, for the two attorneys that are present, take that back to your clients, that whatever it takes, your clients will comply with the law. They will comply with Act 12. Some of those uncomfortable conversations that I'm going to reiterate is A, I want the law followed. B, the intent of the law is, whether you agree with it or not, to put the officers in the schools, hopefully making the schools more safe. And we, meaning the litigants, the community, the media, you can debate, well, do we need 25 officers? Should it be 50? Should it be 12? Should there be none? Should we use the school security aides instead? That's all done. That was all negotiated a year and a half ago. Again, that's like Matt LaFleur and the Philadelphia Eagles. He wasn't prepared. He should have done better. In this case, MPS in the city should have worried about that 18 months ago. That's done. We're past that. Beyond that, the argument that the police officers need all this training, that's a non-starter with this court. MPD has about 1,500 officers. I think it's closer to 1,600. As part of recent legislation, I don't think it was Act 12. It might have been, or might have been another act. They're going to be forced to add officers. The average police officer in Milwaukee, and I've dealt with hundreds of them over the years as witnesses, responding to my court for various issues, testifying, seeing them in action, the vast, vast majority, 98, 99% of the officers for MPD do a good job. They take their job seriously. They're committed for a relatively modest salary to do the best they can to make sure that the citizens and taxpayers of this city are safe, that they're healthy, and that their well-being is kept up. I don't believe that the cops, the 25 officers that are going to be stationed, and they will be, in MPS, need some sort of extensive training. The allegations in this case, which appeared relatively borne out and uncontroverted, are that 2,000 or 3,000 calls a year go out to MPS officers. Well, every one of those officers that runs down to Vincent High School or runs down to Reagan or runs to Rufus King in their squad car needs to be trained. They don't show up, I'm not an officer, no one here is an officer. They're trained by the nature of their job. Now, I would expect that the officers that are put in the schools will have some level of training, of course, how to deal with a 12, 13, 15-year-old, how to deal with school administration. And I would imagine that the training is basically show up at the schools, talk to the principal, talk to the vice principal, work with the security aides, station yourself somewhere visible as a visible deterrent, patrol the hallways, patrol the perimeter of the school, and if there's a problem, deal with it. From my standpoint, I just did the training. No charge. And I'm sure you guys will tell me it's more complicated, but it's not much more complicated. And don't anybody interrupt. This is part of the background and backdrop to my ruling. Given that I'm concerned about the lack of compliance with the law from the two defendants, I'm going to do my best to follow the law. I think that the request from the plaintiffs is appropriate, but I think it's one step ahead of where we are today. The plaintiffs, petitioners can correct me if I'm wrong. Counsel, originally, before filing the amended writ, you filed originally a peremptory writ of mandamus, correct?
Correct.
I think, probably correctly, you amended that basically to give the city time, if I made the requisite findings, which I did, both on the record and in writing at the last hearing, to come to court and either comply with the court's order or show cause as to why they couldn't. Candidly, despite the best efforts of two capable attorneys, I did not hear good cause. I didn't hear cause. I heard a lot of bluster and a lot of argument for the sake of argument. The argument boiled down to, well, Judge, we're still arguing over the financial apportionment and we're arguing over mediators. None of that is good cause for why my order was not complied with. So first of all, hang on one second. As I said earlier, in the law that was passed, statute section 62 related to the school board, school resource officers being required in the schools as of January 1st of last year, so 13, almost 14 months ago. I believe, and I indicated this at the last hearing 3.5 weeks ago, that there's not a reason for me to quash or deny the request. So I'm denying the request to quash or in any way wipe out the peremptory writ. From my review of the case law, the next step needs to be the court issuing a peremptory writ. I'm doing that under these parameters. I'm putting an end today to the debate over finances. There's a gap in the law. My view of the law is judges don't write the law and interpret it. Writing the law is up to the legislature, the governor, and others. They left a huge gap in this law by not just saying what the apportionment should be. So I'm going to fill that gap today based on what's been represented to me, based on the equitable powers of the court, based on fairness. I'm ordering both sides, the city of Milwaukee, meaning the city itself and the police department, to pay 50% of these costs, and MPS to pay 50%. That is also the precedent of that's what the agreement was previously, prior to, I think it was 2020, when the school resource officers were pulled from the schools. That is my order that effective immediately the cost should be split 50-50. And again, that's with the backdrop that these are all numbers and orders, and I expect my orders to be complied with. But the reality is, Ms. Abugrin and city taxpayers are paying the bill no matter what. But the proportionment is 50-50. So we can be done with arguing over who's going to possibly mediate to argue some more. That's the apportionment. And I expect plaintiff's counsel to put that in the order. I'm granting the request for a peremptory writ of mandamus. I'm going to give the defendants 10 days to comply. If they have not complied in the next 10 days, and I'll say, parenthetically, my concern would be that someone, a taxpayer, a commentator, someone in the media could take this as a sign of weakness from the court, or the court backing down. This is not the court backing down. This is the court complying with the law in Wisconsin. I believe that the defendants need to comply now with a peremptory writ, putting in place the school resource officers in the next 10 days. If they're not in the schools in the next 10 days, I will set a hearing and we will take up sanctions, contempt of court, and the allocation of all actual costs to the plaintiff's attorney and to the plaintiff. This ongoing violation of Act 12, this ongoing violation of state law, this ongoing violation, just flaunting of legal and court authority will end. At the next date, I expect either the president or vice president of the school board to be seated next to Ms. Goldberg. I expect the mayor or the mayor's designee. The mayor can designate a chief of staff, the president of the Common Council, the head of DOA, the Department of Administration, the mayor or his designee. I'm not ordering the mayor today because I don't know for a fact the level of his involvement in these negotiations. So the mayor can designate someone to sit with the city attorney. Again, his chief of staff, the president of the Common Council, a high-level staff person, the head of DOA, someone of that sort at the next hearing. I will give the defendants, if this order has not been complied with in the next 10 days, the chance to explain to me why sanctions should not be imposed, why they're not in contempt of court, and why costs should not be incurred. I think as part of a fair and equitable contempt hearing, I will need to hear testimony from either the president or vice president of the school board, the board of school directors, and the designee for the city. Maybe. I think the chances very, very slim and none. But maybe there would be some further explanation. But as of today, there's been no valid, lawful explanation for the continued ongoing violation of the law. And that's what this is, a continued ongoing violation of the law. I said it's going to stop. It's going to stop. I'm confident that either or both lawyers have told their clients, make it a reality. Get it done. Do it. That would be my advice to the city and MPS. Do it. And for the people that are observing this hearing, either directly or indirectly, someone should ask MPS, why has this not been done? Ask the president of the board, why has it not been done? Ask the vice president, why has this not been done? Why do you think you have the ability, legal, ethical, moral, or otherwise, to ignore court orders? You don't. It's a problem in Milwaukee, in Wisconsin, and in society for anyone to think that they're above the law. And it certainly seems in this case that there's at least one entity, if not two, one governmental unit, if not two, that think they're above the law. They're not. I expect the plaintiffs to draft that order within the next 24 hours. The defense attorneys have 24 hours to object only as to form, obviously not as to the merits of the order, but as to form. At that point in time, I would sign the order. My clerk will set a date in approximately 10 days, so it'll be next Wednesday or Thursday. Madam Clerk.
Judge, can you clarify one part of your ruling so that I understand? The statute reads that the school board of the first-class city that is located of the school board in the first-class city shall ensure the school resource officers complete the 40-hour course sponsored by the National Association of School Resource Officers. Will the court find it acceptable that those officers are registered and trained, I don't know logistically, in 10 days that that's possible?
Yes.
Thank you.
How about February 27th at 10 a.m.?
And while we're picking a date to respond to Ms. Colbert, I would expect there to be some ongoing training. Okay, lawyers comply with ongoing training. Judges have ongoing training. I'm sure police officers, I'm confident, I'm 100% sure have ongoing training. So the training